Now we are going to hear about what's really required and what's expected, I think, from a human rights perspective. So I would now like to introduce again Archana Kotecha, who you heard before, who's the head of legal for Liberty Asia. She's going to come back to the stage, and we have two expert panelists who I'm sure will be able to shed some light on some of the statistics that we just heard then, and talk about a blueprint and some really positive actions that we can take, and especially around a paper that Liberty Asia is releasing today as well. So I would like to introduce Helen Colquhoun from DLA Piper, partner and head of employment, and Jelita Pandjaitan from a partner at Linklaters and one of our silver sponsors as well. So thank you, ladies.
Thanks, Kimberly. Welcome back, everybody. And so a few months ago, I read a wonderful opinion written by the law firm Minter Ellison in Australia. And the opinion really focused on how have directors' duties evolved and changed in the light of environmental risks, particularly with greater awareness and knowledge. So how has strategic litigation in the space of the environmental issues changed directors' liabilities and risks, particularly for companies that have an environmental footprint? The opinion was really inspiring. So I set out on my task of finding a law firm that would write me an opinion on directors' duties in relation to modern slavery risks. And guess what? Nobody wanted to do it. Because somewhere along the lines, they all had clients who had these issues, and they didn't want to get caught out in any way saying, this is what could happen to you, etc., etc. So I'm still on the lookout if there's anybody in the room who knows a law firm that might be able to write one for me, pro bono, of course, then I'm most interested. So
maybe that was the issue,
I don't have the dollars, sadly, if there are any donors in the room. So what we did do in the end was something slightly different. So we, Liberty Asia, teamed up with a business and human rights consultancy named Enodo Rights, who are based in New York. And we produced this document, which would have been on your chair or is in the room outside. What the document does is it really outlines a number of areas where liabilities are likely to occur and crystallize. And it then looks at ways in which risks in these areas can be managed by directors. So the idea was to put forward a brief. We were told the C-suite have a very limited attention span. So a very brief, punchy, and proactive document that wasn't saying to them, you're going to go to jail, but it was saying, hey, you might want to do these things, otherwise there could be consequences. Now, I can't imagine a better fit for this conversation than the preceding speaker and the preceding panel. The preceding speaker told you what percentage of the sample did not sign the statement, where there was no explicit board approval. That's saying something. Prue Bennett on the earlier panel talked about how this is not a risk issue, it's not a strategic issue, it's not a boardroom issue. That has to change. And this is what we want to talk a little bit about and explore, and this is why we put this publication out. What can we expect from the C-suite? Leadership, using their leverage. I think a few months ago there was a letter written by the CEO of Blackstone. Is it Blackstone or BlackRock now? I'll get miserably caught out. BlackRock. And you know, I'm having a pink day, as you can tell. That was a really inspiring letter because that talked about profitability, but it talked about sustainability. It talked about social responsibility. And frankly, for where we are at today, we need to see leadership in this space. So that's what we would like to see. And people leaving a positive legacy. So people not just known for building the bottom line, but actually building around social issues that are relevant. So with that in mind, I want to turn to my esteemed panelists. And we're quite fortunate because we have a disputes specialist and we have an employment law specialist. The type of people who C-suites would run to if there was an issue. So I'll ask you both this question. Can you talk us through some of the areas where you're seeing failings and the types of liability triggering issues where you are having to give advice, both from an employment and a disputes perspective? Helen, perhaps you can go first.
Yeah, and as you mentioned, I think the last speaker did a really good job of summarising everything that I was going to say, in that you think it's a given that companies are going to have a policy, that the board will have bought into it, that they'll have signed it, that they'll have done training about it. It seems so obvious, and yet you see a staggering number of very large global organisations that are not doing that. And I'd say the landscape in terms of the clients that are coming to us and the questions that they're asking the human rights team at my firm has really evolved over a very short space of time. So 3 years ago, it was very much corporate social responsibility team, the PR team. It was seen as, we're doing this because we want to tick the box from a reputational perspective. So the advice that we were being asked to give was very country specific. It was very ad hoc. It would be very reactive. So when a new piece of legislation would come in, so for example in the UK in 2015, it was being asked, what do we need to do to comply with this one specific piece of legislation? And in the last, I'd say 12 to 18 months, the dialogue has really started to shift, and we're now seeing clients asking for a much more systematic, coordinated, holistic approach that's not just looking at this as a reputational issue, but as a business risk issue. There's still a long way to go, but the clients that are coming to us are certainly asking for a much more global view. I'd like to think that's because they've woken up and smelt the coffee. I think it's actually because they've seen some of the litigation that's coming out that's scaring them, which is always good for business, frankly. But for example, you've got cases in the US, you've got cases in Canada where they're saying things like the court allowing claims to progress further than companies thought they would. You've got courts being open to the concept that the parent can be liable for the acts of a foreign subsidiary. A parent can be liable for the acts of foreign subcontractors. And that started to make companies think, actually, this is not just about looking at one specific piece of modern slavery legislation in one specific country. And it's not about sitting in Hong Kong and thinking, well, there isn't yet legislation, therefore I'm not covered. Because we've seen cases where the courts are saying, actually, we are going to expand the reach of the legislation that is there. We are going to allow and entertain claims that aren't even based on anti-slavery legislation. So we've seen claims around misleading advertising, around misrepresentation, where you've had companies making very bold statements about, we have zero tolerance, we have stamped out forced labour in our supply chain, and then consumers coming and saying that's not true. So the good news is that we're starting to see a real shift in the last 12 to 18 months. The bad news is there's still an incredibly long way to go, because we still have a lot of companies who are at we'll do the minimum that we need to and we'll tick the boxes that we need to, but then they're falling short on the implementation.
Jelita, how about you?
So Helen's talked a lot about litigation, which is also the area that I operate in. Our clients are coming to us in part concerned about claims risk. I think that's definitely right, and definitely the cross-border claims risk element is a strong feature. But an extending part of the disputes practice within our firm is really around crisis management and situations which have claims risk elements to them, so liability risk elements to them, but go beyond that to multi-front engagements where you've got regulator engagement issues, perhaps other kinds of stakeholder management. You've got the claims piece and perhaps also boycott and consumer activity as well. Obviously, most of these types of situations we deal with relate to multinational corporations, so they're looking at many jurisdictions of concern, and some of the more advanced legislation where the liability risk arises, as Helen says, will be in the more developed locations, but the risks arise in more developing markets where rule of law is not as strong, and we are seeing consumer activism, investor activism, some of which was mentioned on the last panel as well, triggering off significant concern at the board level, definitely, around the possibility of crisis ensuing from the revelation of a slavery issue within the corporate somewhere in the chain, so throughout the supply chain and so on. And plainly, these are issues that have the potential for very substantial financial impact. I mean, that's what we call a crisis. That's how we define it, as an issue that requires that level of attention. It's board-level attention. It's absolutely C-suite devoting their time to resolving a matter, because something like modern slavery, identified or exposed, sometimes even, as we heard earlier, alleged and not proven within a corporate supply chain, has the ability to affect so many of the stakeholder relationships for that corporate. It has an employee disengaging effect. It has a brand taint effect. There can be concern if there's an issue in the supply chain around modern slavery. What other kinds of quality concerns might there be in that supply chain? Does the corporate really understand whether its ingredients are safe if it also has children working in a supply chain environment far from the headquarters, in the UK, the US, or here in Asia? And I think also the last element is this kind of concept of the crime of many crimes and the financial crime elements of modern slavery. So corruption that may be going on gives rise to FCPA risk for our clients who are exposed on the US side or under the UK Bribery Act, and also in many jurisdictions around this part of the world now. Also, there are cross-border elements to that liability. But even just the irregularities in accounting, again, give rise to reputational concern about the governance of the corporate if there may have been funds flowing out to pay for slave-produced product or labour or elements in the supply chain for the company. So it's definitely, I think, a director-level focus issue because it has such a potential to kind of spin out into reputational harm that has the financial bottom line impact that is obviously the director's main concern.
Here's my problem with this. This is very reactive, right? It's something bad happens and then everybody runs for cover, crisis management, etc. One of the key pillars, from my perspective, when you're making a disclosure, is to really ground that disclosure in a robust due diligence procedure. So the due diligence is not tied to the odd deal that is happening here or there or the odd problem, but rather it's a systematic process. Now, in Asia, where we live and work, one of the problems we've had is persuading people that this is relevant to them. I mean, can you shed a bit of light on what you're seeing in your practice? Because certainly as an NGO, when we engage with businesses, we very much hear that this is not a strategic issue for them, and this is not a boardroom issue. So how do we think about changing that?
Yeah, I mean, it's a very tough issue because I think, particularly in Asia, the legislation is what focuses people's mind, or seeing penalties is what focuses people's minds in seeing that this is a real issue that we need to deal with now, and that's what's lacking at the moment. And we've seen litigation in other places. I think it is going to come here and it is going to happen here, and I think looking at it through a proceeds of crime and anti-money laundering lens is going to be a very good way of focusing people's minds. But I think until we start seeing meaningful penalties and biting of legislation, then it's hard to persuade people here to think that it's yet a business critical issue. I mean, it is. I think it's, in some ways, because obviously I come from an employment perspective, in some ways you need a Harvey Weinstein, because the Me Too movement really persuaded companies to shift the way they were looking at the issue. Because previously, even 12 months ago, it was like, well, I'm not hearing about sexual harassment, so therefore it's not happening in my business. Categorically not true. Or it's happening, but nobody's complaining, therefore I don't need to worry about it. Also a very dangerous way of doing business, which has been brought to people's mind in the last 12 months with the Me Too movement. And I think it's a similar kind of analogy here, that there needs to be a shift in focus and people recognizing that if you're not hearing about it, that's a bad thing. And how do you encourage people to come to you first internally and to recognize that your employees, both within this jurisdiction and wherever you have a base of operations, are a hugely valuable source of information in terms of what's going on the ground? And how do you tap into that, and how do you encourage people to be raising information and no longer having the mindset that if I'm not hearing about it, it's not a problem, that's something that's happening to another organisation and not mine?
I think one of
ties
the,
in
so I was
very
just going
well
to say, one of the key elements of this report, which I think is very interesting, is the push on policies and procedures and the director responsibility around ensuring that policies and procedures are in place within the organisation. But it obviously has to go further than that, doesn't it, in terms of, it seems to me that this is one of those issues that directors can give attention to in the same way that they give attention to all other kinds of financial risk in the audited accounts of the corporate. And so they should be asking questions at the board level around whether the policies and procedures are being implemented, what is the discipline record in relation to such issues, and to the oversight of the supply chain and the quality of the supply chain. Are there investigations occurring? Is whistleblowing happening? What kind of records do we have on that? In the same way that you would expect that in relation to any sort of fraud or other financial risk attached to the business. And then, because directors need to be focused on contextual challenging to the accounts, thinking about which markets or countries or jurisdictions of operation are connected to the supply chain, and asking the right questions in those jurisdictions where we know there's higher risk. But I think the challenge around the implementation check by a director is really the critical element to ensuring that those accounts, which is their primary obligation, are accurately reflecting the operation of the business.
I think the remediation part of it is really important. Access to remedy, and what are you offering your workers by way of a remedy in your sort of, your system. If you think about the French law for a moment, the French passed this piece of legislation, which also has a disclosure component to it. But under that piece of law, any person aggrieved in the extended supply chain of the French company could potentially bring a claim in France against the parent company. Now that is, definitely a sort of a leverage point for French companies doing business with supply chains based in Asia to use their leverage to help drive up some standards. Access to remedy, I mean, when you think about remediation mechanisms that often exist across the companies we're encountering, they're mechanisms that don't always work, let alone help to transfer information about where there is exploitation or where there are problems along the line further up the chain, for example, in a whistleblower kind of scenario. So, Jelita, can I just ask you, in Southeast Asia, we often see a lack of freedom of association for workers. There are often criminal defamation suits brought against workers who try to take a case to court against their employers. And of course, there's weak rule of law and everything else. Now, in the context of remediation, what should directors and the C-suite be thinking about when they're looking at their partners or their own operations in this region?
So I think one of the key elements that you just touched upon there, Archana, is the consultation piece, the frontline engagement with affected people. My view around remediation in this particular context, which is similar actually to many other sorts of product harm type contexts, and I see this as effectively a harm that's caused in the process of creating the product, just as you would deal with a product liability issue if the product itself is directly harmful to the consumers of it. Most of this in the context in which I deal in this part of the world is really around actually rehabilitation of the company in terms of its reputation and repositioning with the market and the rest of that. But I think these days are actually expected to engage much more substantively as lawyers within an organisation, often sitting in the C-suite, on the issue of how the corporate can enhance.
We never got round to the training that you told us we should do. You've got the time before this really hits in terms of the legislation to stop and think and have a very systematic, coordinated and sensible approach to how you address this. So I would see this as opportunity time so that you don't need to be calling lawyers.
Big business for lawyers, of course. And I mean, for us, what we did with the publication was we looked at commitment, we looked at due diligence, we looked at disclosure and remediation. The 4 pillars around which you can really build constructive action. Because when liability comes, it's going to come in buckets, and then there will be no hiding, but Jelita will make good business out of it, I'm sure. So we have 5 minutes left. I am conscious that there was no time for questions previously. I want to be an excellent moderator, so I'm going to offer you the opportunity to ask some questions, if you have any. There's a roving mic somewhere.
Thank you so much. My name is Stephanie and I work for Pillnet. I've been thinking a lot about how to structure the right balance between kind of practical approaches, but then also principled approaches. And I've been thinking also about what Mr. Freeman said in an earlier Spotlight talk about how the aspirational collective goal, long term, or hopefully short term, but perhaps long term, is that the private sector will eliminate forced labor from its supply chains without a negative impact on profitability. And what I'm most interested in is when it potentially does have a negative impact on profitability, how you still make the argument that this is important. And I think that's the very difficult question that we'll have to face in the near term, and I'm curious to hear what your thoughts are on this topic.
From the NGO world, I can tell you this. When the Modern Slavery Act came into force, everybody was very excited. It started lots of really important discussions, and there's no doubt that it was a significant turning point. What is even more interesting is how directors are now being prosecuted under the Modern Slavery Act for slavery found in their supply chain. And there have been quite a few cases already successfully prosecuted. And you know, that's the reality of it. If people are not going to find a way of being proactive, dealing, managing, identifying these risks, then their hand will be forced by legislation, by case law, and transnational case law. We are hearing cases out of Korea being heard in France. I mean, the borders will no longer matter. And that's where it's headed. So from the perspective of what we're seeing from where we're sitting, there has to be action in terms of legislation in order to prompt or to push change in the right direction. And granted that the Modern Slavery Act disclosure requirements are reasonably soft, but the other provisions in the Modern Slavery Act have been tremendously helpful from a corporate accountability perspective. Helen and Jelita, I'll let you comment a bit further.
Yeah, I was just going to say there's nothing like individual director liability to focus the mind of a board. So I think it's very helpful, not for those individuals, but from a global perspective, that we are seeing some prosecutions coming through. So I mean, I would genuinely, to any C-suite director who thinks he doesn't need to be thinking about this, say good luck and check your D&O insurance policy. Like, I really think this is something that I think ultimately the legislation will follow, but it will be the contextual pressures of investor demands, questions being asked at AGMs. We're seeing that happening with Facebook, with Amazon, for example. Questions were asked at their AGMs about specific issues or what they were doing. That there's this commercial impetus that's forcing companies to be ahead of the legislation.
I definitely see modern slavery as a real issue around sustainability of business. And I think it's the concept of it being anti-profit or dealing with slavery as being an anti-profitable move, to me, is just anathema in the present day. And, you know, apropos of the comments I made about sort of crises, but also the panel earlier talking about ESG as a proxy for sustainable profitability, actually. So it's the converse almost of suggesting that there's a concern about profit. So I'm not naive in thinking that everybody thinks that way now, but I definitely see it coming, and I think the liability piece is part of it, but the huge financial impact of crises and of reputational and brand harm should be keeping directors awake at night in a concern about ensuring that there is enough risk management around this issue from the board level all the way through the organisation.
Yeah, and I would just add to that, particularly from a brand reputation perspective, you see nowadays that a tweet can wipe millions, if not more, off a company's value. So it doesn't need to be that somebody brings litigation against your company in order for your bottom line to be massively impacted. I mean, I know it's not a slavery issue, but you've seen Tesla and the fun they've been having because of tweets in the last couple of weeks. So I think companies, even if they don't think there's a legal requirement, are seeing that they can have significant impact by somebody who's disgruntled complaining, whether it's a valid complaint or not. The damage is done by the time the company's run to crisis management mode.
Any further questions? Yeah, we have one more at the back. Oh, two more.
Oh, thank you. My question is also on profitability, because I think that's the thing that will really make the companies think. And at the previous panel, we didn't have a chance to ask questions. And then afterwards, I spoke to one of the speakers, Mr. Colquhoun Sweeney. But his answer was just the opposite. He said, actually, if they try to tackle slavery, it's more profitable. So, and I said, if that is really true, then you should spread the message. So I think that if we can get people who have such message, they should tell the world. Maybe if they try to tackle slavery, they lose money, which is what we think. But actually, in the case of some companies, they actually become more profitable. So I don't know whether you will allow Mr. Colquhoun Sweeney to say something. And I think that's a brilliant message. And that's a message that should go around the world.
Yeah, you
And
should
if
tweet
you
it,
tackle
it will go
slavery,
viral.
you make more money.
Thanks, Emily. There was one more question.
Hi, Archana. My name is Rahul. I represent Asia Inspection. We have a lot of retailers and brands here and some of the NGOs and who have been working with lots of brands and retailers. But in the same scenario, you have now e-commerce retailers. You have biggest ones in US and Germany. How do you see those e-commerce, having their impact on modern slavery? What are they doing about it? Because as far as I know, most of them say, oh, we are the third-party, platforms provider. We have sellers on our platform, so it's their job to manage modern slavery in their supply chain wherever they are procuring from. We are just, a platform. So how do you see that scenario in terms of e-commerce and modern slavery? How do these two go together?
The answer to that is Backpage. Do you know what happened to Backpage? Backpage was hosting classified ads that was selling children, women, who had been trafficked and who were being further exploited. The CEO of Backpage is now in prison and is paying the price for it. The point is that hosting comes with responsibilities. Facebook, as we speak, is also facing a lot of scrutiny over posts that they allow, over videos that are uploaded that then have consequences. So similarly, e-commerce platforms are not going to be devoid of responsibility going forwards, because if you're putting on your space retailers, etc., then there will be an expected responsibility that comes with that. This is still a nascent space. It's still developing. I don't know how that will shape out. Possibly the lawyers have a different view to me on that.
No, I'd agree. I mean, again, I think it's an area where the law's trying to keep up with the way business is now done, but if it hasn't yet caught up somewhere, it will do so, because absolutely, I think conceptually, the view is that there shouldn't be an abdication of responsibility by saying, well, I'm not responsible for what I'm putting out there or for what I'm making profit from, because you are making profit from that way of doing business. So there will be a point at which the buck stops with you.
Well, thank you very much, everybody. Please join me in thanking our panelists. Thanks.